I acknowledge the Turrbal and Yagara peoples as the traditional owners of the land on which the University of Queensland sits, and pay my respects to their elders past and present, and recognise their continuing connection to country. As Greg alluded to in his introduction, the Brereton inquiry did come out yesterday. This is an inquiry that is long anticipated, and so when I agreed to do this talk today, it was certainly likely that it might come out in the coming weeks, but I didn't quite anticipate it coming out the day before. And of course, the Chief of the Defence Force yesterday acknowledged that this was possibly the most disgraceful episode in Australia's military history. And clearly there is a lot of attention in the Australian media and no doubt internationally as well on this particular topic. I am going to be talking about ensuring respect for international humanitarian law in terms of respect that countries, or actions that countries can take to ensure respect by third states. And I'll explain that in a little bit more detail. But I think before doing that, it's important to acknowledge what happened yesterday and talk about that in a little bit more detail. So the focus of my work is in relation to Common Article 1 of the Geneva Conventions of August 1949. And these four key documents are the core documents that dictate behaviour in times of armed conflict. They're the key legal framework for the law of armed conflict. I'm going to be talking specifically about the first article, common to all four Geneva Conventions and 2 of the 3 additional protocols, not included in Additional Protocol 2, which speaks specifically about non-international armed conflict, but common to all other core documents. And it is a provision that really did not attract a lot of attention in the drafting, and which has created some discussion in recent times, particularly around the notion of ensuring respect. But there are 2 components to this provision. The high contracting parties undertake to respect and to ensure respect for the present convention. And the release of the Brereton report yesterday means that it is definitely worth a closer look at the notion of respect in the Australian context. Now, there are some strong linkages in the Brereton inquiry in relation to respect for international humanitarian law. And this is about the actions that Australia takes and can take domestically to ensure that it's got its own house in order, that it's doing the right thing. As you will be aware, the report has identified 23 instances and recommended charges for violations of the Criminal Code, which imports war crimes laws into Australian domestic law. And it has done so as from events that have resulted in the killing of 39 civilians and the cruel treatment of 2 others in Afghanistan by Australian SAS forces. The government has announced that there will be an Office of a Special Investigator to take these criminal matters forward and address them. And as signatories to the Geneva Conventions, it's really important that Australia does this. We have a specific legal obligation to investigate and, where appropriate, to prosecute those who have violated the law of armed conflict. And complying with that provision is really important and a really key part of respecting the law of war. Additionally, as a party to the International Criminal Court, Australia owes the soldiers involved, as well as the international community, a fair trial and a duly comprised court of law. The Australian government's position in relation to the International Criminal Court is that whilst we are signatories and we support it, no Australian soldier would ever end up before the court, because the Australian government would prosecute them appropriately if they were found from an investigation to warrant that prosecution. So that's a really important point. However, as the Brereton inquiry details in a number of pages, the Australian record in relation to prosecutions is not a good record. We do not have both in relation to prosecuting Australian soldiers or to prosecuting others, for example, the Nazi-era war criminals, a good record in this regard. And so this is really very much a moment of reckoning for Australia. We have to do this right, and accountability for these actions is really key to ensuring that Australia is respecting the law of war. But I think it's important, whilst the focus will definitely be on the war crimes prosecution component, I think it's really important to reflect on the fact that respect is not just about accountability. Accountability is a really key component, but it's not the full story. And so in relation to other areas of respect, the Brereton Inquiry makes a few recommendations that I just thought I would flag for today's purposes. We certainly don't have time to go through 456 pages, albeit some of them very redacted. One of the core components that us in international humanitarian law always talk about for respecting the law of war is it's so important that you know and you understand the law of war. You can't respect it if you don't know it. But what is really clear from the evidence that has been presented in the inquiry report is that that is not really the issue here. The Australian soldiers were very clearly knowledgeable about the rules of war, and the evidence is that they took very specific actions to make their actions look like they were compliant with the law of war. So that is an important part. There must be continual international humanitarian law training for soldiers, and indeed in my career I have been involved in that both for Australian Defence Force personnel as well as military personnel from other defence forces. That's an important part, and that's continuous. But there's perhaps some broader things that Australia can also think about here, and I just thought I'd flag a couple of them that the Brereton Inquiry raises. So one of them is about the culture of accountability, and it's about the idea that you have to report things that are wrong and things that are in violation of the law of war. And the Brereton Inquiry report specifically mentions that the appreciation must be shown to those who spoke up, and indeed General Campbell mentioned that in his press release yesterday, but also specifically identifies that promotion of those who spoke up should be a really swift action by the Australian Defence Forces to start to create this culture that values this as a trait over the sort of traditional idea of loyalty, even in the face of violations of the law of war. Loyalty is a really important part of military ethos, but it should always be overridden, of course, by obligations under international law. The other point that I just wanted to flag that I thought was really quite interesting was looking at the science of the high tempo of deployment rotations and the dependence of the Australian Defence Force on the SAS for their work. Australia has become very dependent on these small groups of very highly trained soldiers, and this has meant that they have been deployed constantly. I think some of them, they were talking in the report about 11 deployments to Afghanistan over the last number of years. And so having Australian government policy on how often and how frequently you can be deployed and how we use the different elements of our military service are potentially really valuable, ensuring respect tools that the Australian government can engage in. The final point to make is that whilst there will be a lot of focus on the special investigator, there has also been the appointment of an oversight panel. And this panel's job, which will look at the response of Australia, but it also includes reviewing the command element and related policies associated to the deployment of Australian forces. And so whilst the prosecutions might be the headline news, I'd like to suggest that it's really important that we also consider these broader respect measures, and that these measures are just as important for the victims. They're just as important for Australia's reputation, but they're also really important for the women and men who serve in the Defence Force, and for their ability to reckon with what has taken place. So that's a couple of comments about the Brereton inquiry. And I'm sure there may be questions on that, but I will return now to sort of the original concept behind the presentation, which, as Greg mentioned, is very much based on my PhD thesis and also an edited collection that recently came out. And the purpose of this work was to look at this notion of ensuring respect, this idea that the high contracting parties undertake to ensure respect for the laws of war. Now, you can see on the slide here, there's a couple of indications of what that might have been intended to be. And as I mentioned, there was very little attention on the drafting convention for this. And so you have some people saying, well, this is a pretty innocuous opening phrase that doesn't really mean much. You, at the other end of the extremes, have academics saying, well, this is a nucleus for the system of collective responsibility. This is a really, really important part. Kalshoven's description of Common Article 1 as a tiny seed that's becoming a ripening fruit seems to me, in the research that I've done, to be one that makes a lot of sense. And there has been a lot of interest in this provision in academic and to some degree state circles because of a project by the International Committee of the Red Cross to update the commentaries that accompany the Geneva Conventions. And in 2016, they released the first updated commentary to the first Geneva Convention where this particular provision was addressed. And state responses to that have then contributed to the conversation. I'll give you a little bit of background about what I talked about in some of the research to kind of understand what this provision means. But then we'll talk a bit more about the book. And the book is very much about the practical measures that could give effect to the obligation to ensure respect. So talking about the practical measures is very much the focus of the book in ensuring respect for the law. But I will just also talk about the interpretive approach to the actual provision itself. And this was very much the focus of some of the work in my PhD thesis, which I did do at UQ, and Anthony Casamatis was one of my supervisors, as well as Jonathan Crowe. So in trying to understand what Common Article 1 means, despite perhaps not a lot of attention being given to it in the drafting phase, and this idea of it being a fairly innocuous provision, I looked at the Vienna Convention on the Law of Treaties interpretation of legal provisions, and in particular the state practice, other relevant rules of international law, and the drafting history of the provision. And so in looking at these, there are examples from United Nations Security Council and General Assembly resolutions, as well as international case law, such as the Nicaragua judgment and the Wall Advisory Opinion, which really demonstrate that this is seen as a provision that requires third states to do certain things, not in all circumstances, but that where they can, they take action, and that they support another state. And so it was very clear that it had a third state element to it. The ultimate findings in more recent times, and particularly in the analysis of the International Committee of the Red Cross, is this idea around due diligence. And so the idea is that a state must use the capacity and the influence that it has to help third states ensure respect for the law of war. There is therefore a great deal of difference between what a state that is perhaps a neighbouring state, or a state that is very wealthy, or a state that is highly influential in a particular context can do, compared to a state small state on the other side of the world who has no real influence. And this was very much recognised. If you said that the obligation to ensure respect meant that every state had to respond to every single situation, you'd essentially, as some of the commentators have noted, have a situation of 190 something breaches of the conventions every single time there was a breach of the convention, because all of the other states would be responsible. So the determination in terms of what does this really mean is very much around the notion of capacity and influence. What became really apparent is that there are differing views on this. There is people who talk about morality versus legality in terms of this provision. There are some states who have very clearly rejected what they call the International Committee of the Red Cross's very wide interpretation. There are other states who've said sort of, oh, maybe, but we don't really want to make a decision on this. There's obviously a lot of states who've said nothing. And so in trying to think about how to take this forward, the idea was that rather than go, well, this is the law and this is exactly what the law looks like, it would be much more useful to look at what some practical measures might be which would give effect to the obligation, rather than worry too much about the exact parameters of the legal obligation. And so that's where the book project comes in. So with a former colleague, Annabelle McConaughey, and with a range of international experts who have technical expertise in different areas of international humanitarian law, we have created this edited collection which seeks to kind of apply this concept that you ensure respect by helping third states and making sure your actions help third states across a range of different areas of international humanitarian law. So you can see from the bolded parts on the slides that we've got experts talking about, well, what does humanitarian diplomacy do in this area? What can parliamentary committees do in this area? What can private actors do in this area? What are the ensure respect components of targeting or the use of weapons? Questions around the obligation and peacekeeping and detention. And then some really sort of specific and topical areas such as counter-terrorism or foreign fighting, and particularly interesting one of recent times is this idea of humanitarian activities, and this idea of, can you just go into a third state and provide humanitarian assistance, and what are the consent requirements around those sorts of issues. And of course, the book does include a component on international criminal tribunals and their role in ensuring respect, and the value of criminal law, obviously both domestic and international, in this. The work that I did specifically in my PhD component was around weapons. And so I looked at how Australia approached weapons law regulation to give effect to the obligation to ensure respect for international humanitarian law. So under the laws of war to which Australia is a party, Additional Protocol 1 of the Geneva Convention, there is an obligation that when you get a new weapon, or you're developing a new weapon, or you're devising a new weapon, or a tactic or a strategy of warfare, you conduct a review to check whether you can use that weapon in compliance with international humanitarian law. There's also, of course, specific treaty obligations. And so I use the, for example, here to indicate the 4 case studies that I looked at: the landmines, anti-personnel landmines convention, the prohibition of cluster munitions. For those who are not military-minded, a lay definition of a cluster munition is essentially those bombs that have lots of little bomblets within them, and when you release the big bomb, the little bomblets scatter from the sort of larger capsule. The arms trade treaty, so not a prohibition treaty, but a regulation of small arms and light weapons and other military hardware, and nuclear weapons. And so when I engaged in this work, the Prohibition on Nuclear Weapons Treaty did not exist, but it has very recently had its 50th signatory state and will soon come into force. But throughout the process of the sort of 5 years before this, so 2010 to 2015, the Australian government were involved in negotiations on this particular topic. I also looked at training and doctrine, again, reiterating that idea that you can't obey the legal framework unless you know what it is. The import and export control framework, so in respecting and ensuring respect for the law of war, you need to have an import and export control framework that prevents, for example, weapons that would violate international humanitarian law from being able to be traded with your country. Obviously, you need to criminalise the violations that might take place as a result of the use of weapons, and you need to prosecute them. So with the disclaimer that this is very much a very brief sort of overview summary with a little asterisk there, this is essentially the conclusions that the work came to in terms of these different areas. So Australia has a very robust weapons review process, and that is something, in my experience, engaging with Department of Defence, they take very seriously and are very engaged with. In terms of specific treaty obligations, there's certainly some criticisms of Australia's approach to regulating cluster munitions and nuclear weapons that are very strongly linked to alliances, Australian alliances, and Australia's stated objective to ensure that some of their allies are able to use these particular weapons, although we do not use them as Australia itself. And this can be contrasted to a pretty strong and robust approach by the Australian government on landmines and the Arms Trade Treaty, which we actually chaired some of the negotiations of. As I mentioned at the outset, I think Australia's training and doctrine on respecting these issues is pretty robust, and that's been my personal experience as well as my academic experience. On the issue of import and export controls, I think the jury is still out. We have quite a lot of lists and work in that area, but there is definitely issues in terms of our relationships with trading specific military hardware. In relation to the criminalisation of violations, under current legal frameworks, although it did take Australia some time to get to these amendments, but fairly comprehensive. And then in relation to the prosecution of violations, as I mentioned, a fairly poor historical record and obviously a question mark, but apparently heading in the right direction with an appointment of the special investigator and a commitment by the Defence Forces to take this very seriously. So that's just kind of one chapter of the book and just gives you a bit of a snapshot of where the sorts of issues that can be discussed in terms of practical measures that states can engage in, and very much shows the linkage between states respecting the law of war at home and their ability to do so overseas. And so by way of conclusions then, we were able from the book, my colleague Annabelle and myself, to really draw some themes that were emerging from all of those different chapters of different areas of technical expertise. Themes emerging about you've got to have your own house in order to give effect to this obligation. You've got to contribute to building normative frameworks and legal frameworks in the international arena. And there's some examples in the book. The Kampala Convention on the Protection of Internally Displaced People in Africa is a document that I've worked on a little bit myself, and is a document that in many African jurisdictions has really been embraced domestically in order to try and increase those protections. The Arms Trade Treaty is another example. If states are a party to the Arms Trade Treaty and they respect it domestically and they implement it domestically, then they're going to have a really strong contribution to ensuring respect for the law of war, because the Arms Trade Treaty prevents you from transferring small arms and light weapons, ammunition and other military hardware to which it applies, where there is a serious risk of a violation of the law of armed conflict. And then the final component is direct action. And so absolutely there's some direct actions that states can take to give effect. And perhaps the chapter on diplomatic processes and humanitarian diplomacy is the one that shows this the most, the dialogue and the engagement and the voting at international levels to create the environment of ensuring respect, as well as some really positive domestic measures. So a former colleague of mine from Nairobi, Dr. Ken Matuma, talks about the different things that Kenya has done, and not perfect, that more could be done, but to create domestic legal frameworks that ensure respect for the law of war in South Sudan. And he talks particularly about regulating the banking sector in Kenya, which funnels a lot of the money into the conflict in South Sudan, and how regulation of the banking sector is able to reduce those risks. And so whilst we may have set out to, I guess, create a bit of a checklist of practical measures that states could take to ensure respect by third states, what we essentially ended up with is more of a toolbox of measures. And states can therefore, based on their capacity and influence and due diligence processes, work out which measures suit the circumstances the best. But absolutely, the book was never intended to provide an answer. It was absolutely intended to be a catalyst for discussion. I think there's a lot more chapters that the book could have in terms of different topics the book could talk about this issue through the lens of. But also we are interested to see the responses from others in the field to determine the contribution that can be made going forward.